Okay, the record reflects we have everyone here. Council, forgive me, I was listening in earlier this morning, but your jacket is not moving or doing anything here. I was testing my equipment.
Thank you. One less thing to be worried about.
Yes, dear, you're coming in clear and fine, and you're not moving, although I noticed earlier today my robe was twitching in one of the oral arguments, so hopefully I'm closer behind the green screen now.
I assure you I won't notice. I think it makes you more nervous when you have to watch all of the other arguments in front of you, but.
I thank you for that. I will need to ask you, since I am designated as Center Chair today, I'm also the timekeeper, so I get time to multitask. Would you like to reserve any time for your rebuttal?
I would, yes, Your Honor. I'd like to reserve 5 minutes. Thank you.
And I will do my best to let you know when you arrive at 15 minutes. I know you know that if you want to keep going, it's still your remaining 5 minutes. We just subtract them from your 20. That's all. So Excellent. It's not one of those where you have to sit down right then or stand. It's your time still. With that being said, Council, we are ready to begin. And as they say, the floor is yours.
Thank you. May it please the court. My name is Shannon Zettrauer, and I represent the appellant Sharon Jacobson. This appeal raises 3 issues based on the legal interpretation of a postnuptial contract between former spouses regarding the equitable distribution that would occur upon the sale of the marital home. In each instance, the circuit court's judgment conflicts with the plain language of the postnuptial agreement. First, the final judgment conflicts with the plain language of the postnuptial agreement that requires all benefits realized from the sale of the property must be included when calculating wife's share when the sale is not a bona fide sale. The side letter agreement is the primary reason why the sale was not a bona fide sale, although it also wasn't a bona fide sale because it wasn't an arm's length transaction, as the buyer admittedly had a financial relationship with an interested party, Mark Jacobson. Appellee conceded below that this was not a bona fide sale. That's not in dispute, precisely because the sales transaction included $500,000 for unvalued.
Did they concede it wasn't a bona fide sale because the son found the buyer and he's a beneficiary under the residence, should he live long enough, the owner, and that element of the contract caused it not to be a bona fide sale? Was that correct?
Yes, Your Honor, and they also conceded that it was not a bona fide sale because there was $500,000 of personal property that was sold not for the fair market value.
Okay. Did they say the value was higher or lesser?
They didn't know.
Okay. So going back to your first point, is to prohibit benefits from the sale of the property. And the property identified in the contract to which the former wife had an interest was the house and the adjoining lot. This is a sale of personalty. What's the nexus, if any, between the two?
The nexus, Your Honor, is the fact that it wasn't a bona fide sale. So because it wasn't a bona fide sale, and if you look at the agreement, it gives several specific examples of what would not make it a bona fide sale. And the first example is if there's a corresponding or related sale of personal property that is sold that's not for the fair market value. That's what happened here. So that makes it not a bona fide sale. And what the agreement does then is it changes the formula for gross proceeds to include the amount for that personal property. So that's how the personal property became a part of the gross proceeds. The personal property would not have been a part of the gross proceeds had they either not sold it with the house or they could have sold it with the home. And all they had to do is sell it for the fair market value.
Who would have the burden of establishing that it wasn't fair market value? I mean, there's a list of all the attachments. The property belonged to the former husband. Why does it matter if he sold it for less than it was worth?
Because that's what the agreement required. We don't know if he sold it for, I mean,
that is part of my concern. The argument to benefit the wife says it has to benefit from the sale, and the benefit suggests that it has to be a positive, and there's no proof in this record that it's a positive that he benefited. He just sold his property, and everybody agrees it's not for fair market value. That means it's either up or down. One's a benefit, one's a loss, and that's my How do I address that in terms of the, as you argue, the strict language of the agreement, or am I going too far afield?
Well, no, Your Honor, I think it's a good question. The benefit is $500,000. That's the benefit. That's undisputed. No one is disputing the amount.
So whatever the sale price is, it would have been a benefit. So if he'd have sold it for $100, then your argument it would have been, we'd have taken an appeal for the $100 because it should have been in the gross proceeds. Or is there a point where that nexus, he has to benefit from it? I mean, no. A positive. So any amount of income arguably would then be a positive gain. Is that it? Any amount of sale price would be a positive, i.e. therefore a benefit?
Exactly, Your Honor. Then it should be included in the gross proceeds per the formula in the agreement. I don't know that we would have appealed it for $100.
I know, I didn't, that was just a, you know, my concern there is if the purpose of this clause was to make sure that the husband didn't park proceeds over in the sale that would have otherwise been in the other portion of the sale proceeds under the contract, I'm not sure the record clearly displays that's what happened here. I mean, that clause is to protect the former wife from saying the husband sells a market value property of 100 units at 50 and then parks 50 over there somewhere else and saying, oh, you only get 50. In this case, it appears that it was sold above the appraisal price. So that causes some concern about the nexus and the benefits. And I'm trying to figure out how all this should be interrelated, if at all.
And Your Honor, you hit on a couple of key points that I wasn't going to get into, but the first draft of the side, or the first signed copy of the side letter agreement saying they would give $500,000 for personal property listed no personal property. So it does appear what you suggested happened, where it was, we're going to park $500,000 of the sale price over here and deem it for personal property. You also mentioned the appraisal, and I believe when you say the appraisal, you're talking about the appraisal of the marital home.
And did not include the adjoining lot, because that would have had a value too, right?
It did. It did include the adjoining lot. However, it didn't appropriately account for that. However, I would say the appraisal is a bit of a red herring, and I can spend time on it if you'd like.
No. I mean, part of the agreement says the adjoining lot's not the property of the wife anyway. At least one of them did. I know if it was the first one, the second one, I'd have to go back and double check because I don't want to, there's a lot in your record.
Right. She was entitled to the adjoining lot as well, Your Honor. However, the appraisal is irrelevant because the agreements, first, they didn't trigger the appraisal process, which had to have been done within 15 days of the sale. They didn't bring it up till 18 months later. But also the appraisal, the agreement states that it's either the higher of the gross proceeds being the sales price plus benefits realized or the appraisal amount. So unless we had an appraisal that was higher than this amount, the appraisal is irrelevant anyhow. But while we're talking about the appraisal, I will also mention that it did state in it that it was based on extraordinary assumptions. It was done from the curb without going inside of this home.
He had walked back in the house for quite a while. Yeah, he said he saw it one time before, but didn't go back in.
Right, 6 years before. And I really don't, I'd be happy to address it because there are a ton of issues.
No, I don't want to take up all your time. You've addressed my question about the interlocking aspects of the language.
Okay. And I know you gave someone else 2 extra minutes, so I may need that, but let's keep going. All right, thank you, judges. So the side letter agreement, as I said, was the primary reason why the sale is not a bona fide sale. And we just discussed that quite a bit. Appellee conceded this was not a bona fide sale because of that $500,000. And because this was not a bona fide sale, that formula changed. So the formula to determine gross proceeds was no longer just the sales price. It's now the benefits realized by the husband pursuant to the transfer plus the sales price. And there's no dispute that receiving $500,000 for some amount of personal property is a benefit realized by the husband. The postnuptial agreement pursuant to the transfer, it's a benefit realized pursuant to the transfer. And the postnuptial agreement's definition of transfer is very broad. It's any sale of any interest in the property in any manner whatsoever. Postnuptial agreement required the property to be sold in a transaction meeting all of the requirements of a bona fide sale and prohibited husband from engaging in any transaction or transfer or agreement concerning a transfer that evades or avoids the bona fide sale requirement. There's no question that that $500,000 was a benefit realized by the husband pursuant to the transfer of the marital home and an agreement concerning the transfer of the marital home. The marital home sale and side letter agreement's personal property sale closed simultaneously. The contracts reference one another, and the side letter agreement was contingent on the marital home's closing. Had it not been for that sale.
I saw that in your brief, and the question I have is, I mean, can any sale of property that's located inside of a residence, if the residence doesn't actually close, you're not going to go forward with the sale of the personal property. So, I mean, going back to what you said earlier about them not having a list of the property, this was basically the contents of this house, was it not?
I don't know, Your Honor. We were not permitted to go in and see exactly what was sold, so we don't know. But there was a substantial list.
This wasn't just, hey, I'm selling you the dishes and the dining room set for $500,000. This was a substantial amount of property, correct? Basically selling it as furnished.
There was quite a lengthy list.
You should proceed.
Thank you. Second, the circuit court erred by crediting husband for claimed capital expenditures that lacked the adequate backup documentation that the postnuptial agreement expressly required before such expenses would decrease wife's share of the sale proceeds. Under the agreement's plain language, those claims had to be excluded. The postnuptial agreement required strict performance of its terms and conditions, and even stated that substantial performance in good faith would not be sufficient. The postnuptial agreement's process was straightforward. Husband was to notify his wife of the claimed expenses, then she had the right to verify his records to confirm that these were actual capital improvements pursuant to the strict terms of the agreement. Rather than hold the husband to the postnuptial agreement's unambiguous and strict record-keeping requirements, the circuit court permitted appellee to support all of his pre-2011 claims, which were 102 in total, totaling over $200,000, without a single document and evidence to support those. 0 documents cannot constitute adequate records or backup information documenting those claims. Allowing those claims with no evidence was error as a matter of law. For the 2015 to 2016 purported capital improvements, there were some records, but they were substantially lacking. There were no records to show that husband actually paid for these claimed improvements. The bulk of those improvements were paid via check from a Morgan Stanley account, but there wasn't a single record or piece of documentary evidence showing the owner of that account. Instead of the records, appellee presented the testimony of Mark Jacobson, husband's son, and that testimony was inadequate for 2 reasons. First, the testimony was inadequate per the postnuptial agreement's plain language because records were required. No testimony could be adequate because testimony is not records. Second, even if the testimony could be records under the agreement, which it cannot, Mark's testimony was inadmissible to establish that husband owned the subject Morgan Stanley account because his purported knowledge that husband owned the account in question could only come from reviewing the unadmitted business records. Our briefs lay out the case law on this, but when a witness testifies as to the contents of business records, the business records must be in evidence. Otherwise, the testimony is inadmissible, and allowing Mark to testify without the account records and evidence was an abuse of discretion. The postnuptial agreement's records and documentation requirements mean actual records, documents, not testimony of people who benefit if wife receives less. When the circuit court permitted appellee to substitute trial testimony, it rewrote the terms of the agreement and deprived the wife of a key protection she bargained for and received under the agreement's terms. Without the records, wife had no ability to determine if these were true capital improvements, and the requirements for those to be included as capital improvements under the agreement were very strict, and she was unable to perform that analysis without all of the documentation. It's undisputed that 0 underlying records were admitted to establish the pre-2011 expenses, and those claims must be stricken. Further, no record shows that husband paid for the great majority of the claimed improvements from 2015 to 2016. Third, the circuit court erred by crediting the husband for his attorney's fees when the postnuptial agreement only permitted a credit for reasonable selling expenses paid to an independent third parties. The husband's claim for $15,000 in legal fees as a reasonable selling expense was raised for the first time in this litigation at closing argument. It was not claimed in the complaint or after the actual closing of the property. Wife timely objected to the inclusion of these amounts. There is no evidence, let alone competent substantial evidence, that husband's attorney's fees were independent or reasonable, and therefore they cannot reduce the net proceeds. Appellee and husband had all of the records that would document these expenses. They chose not to provide them to wife, which prevented wife from proving that they were not legitimate expenses per the agreement. To briefly conclude now, the circuit court was required to interpret and enforce the postnuptial agreement's plain language and expressed intent. Instead, its ruling read out key language and excused noncompliance with several material provisions. These legal errors should be reversed and remanded with instructions to amend the judgment to include for wife $250,000 for half of the benefits realized from the side letter agreement, $102,692.92, which is half of the entirely undocumented pre-2011 expenses, $291,558.17, which is half of the insufficiently documented 2015 to 2016 expenses, and $7,592.50, which is half of husband's claimed selling expenses for attorney's fees. Appellee referenced in his brief that a wife wants another pound of flesh, but that's not true. Husband lived in the marital home.
I thought you were about to sum up with the numbers, so I didn't interrupt you, but you are past the 15. I just want to make sure you knew that.
Okay, I'll wrap up right now then, Your Honor. Husband sold the home for $6 million and afterwards cut wife a check for $11,000. Wife doesn't want a pound of flesh. She merely wants her equitable share pursuant to the unambiguous terms of the agreement. Thank you.
Thank you. Mr. Samarcos, you are muted. I think you want to speak with us, and you are still muted according to you're good now. Okay.
You know, I've been watching that, and I said, I'm not going to do this. And then I just,
I keep catching myself here, you know, and trying to make sure in case I make a noise over here, I'm muted, and so I don't disturb you. And then I know I'm trying to advise counsel, I'm sorry you're there, and I'm going, oh, I'm muted. I got to turn myself back on.
We all do it.
It's funny. I was telling somebody, I haven't been in a courtroom since March of 2020, and I've been practicing 32 years. And it really is a completely different year. I'm like old now, and it's very difficult to adjust to not being in front of people. And the mute thing happens to me frequently because I try not to interrupt. So thank you for telling me.
Well, as I say, the counsel, the floor is yours now at this time. You may proceed.
May it please the court. Thank you. Charles Samarcos, I'm representing the appellee, Martin Jacobson, who's the trustee of his father's personal residential trust. I'd like to start with the first argument that was addressed, which is the sale of the personal property. Factually, by background, what's critical in this case is that if you look at the agreement, and especially in subparagraph 2, the nature of the wife's interest is critical because the parties agree that it was the intent and the agreement of the parties that the additional amount that the wife would receive would be equitable distribution for purposes of marital assets and liabilities. Why this is critical is because all of the personal property we're talking about is husband's separate property, either acquired post-marriage or abandoned by the former wife under the 1994 decree. So therefore, when the court, especially the lower court, and these were argued, is looking at what the intent of the parties was, this is equitable distribution. And I know that your honors are aware, courts don't have jurisdiction over post-marital assets to then say, we're going to go back and look what somebody acquired later and equitably distribute them after the marriage. That's why this is a critical agreement. When looking at the overall intent, they want to say, well, we're taking out the word benefit and we're ascribing to it a meaning that he got a benefit, therefore we get that money. But
you can agree to something in a marital settlement agreement that trial courts can't authorize. Isn't that correct?
You can personally agree to it, but the difference is that they said that this was only going to be equitable distribution property, which would be assets and liabilities that were owned at the time of the marriage, not subsequent. And the problem with that, Your Honor, is that these assets are subsequent because, number one, after a year, they weren't removed. Number two, they were personal property and it's not established that all of it existed at the time. The furniture, the fixtures, the piano, there's no establishment of that. So that's a critical factor. Also, Your Honor, when looking at the transfer and the benefit, and this was argued at the lower court, and it was also even established by Mr. Braunstein's testimony. Had this house sold for $4 million, and let's say Mr. Braunstein, I think, said a Ferrari, and the sales price on the contract said $4 million, but there's another document that's a bill of sale that transfers a Ferrari. Clearly, that would have been a benefit received for the sale because Mr. Jacobson's trust was going to be receiving something of value. That was a benefit to him. Or take it away. Let's say that he sold the house and there was a promissory note that was reduced by $1 million. Let's say that that Mr. Jacobson owed the buyer $1 million and the buyer said, okay, I'm paying you $4 million for the house and the $1 million note I'm canceling. Clearly, that's a benefit to Mr. Jacobson that would be included in the sales proceeds. And the other thing that happens with this, like in typical transactions, sometimes somebody stays rent-free 6-7 months later. That's a benefit received. I'm selling the house. I'm staying there for 6 months. There's no testimony like that any of that happened. What they argue is, and Judge Casanova, I think you nailed this on the head with the hammer, because there is no testimony that the personal property sold was a benefit. All that happened is that one asset in the form of tangible personal property was converted to another asset in the form of cash. But there is no testimony that there was a gain, that somehow the grand piano, the piano was sold for $100,000 more than it was worth, or the glassware or the furniture. In fact, to the contrary, there is no evidence to say that this was not an arm's length transaction on the personal property. And even to the contrary of that, the former wife's testimony as a decorator essentially established that if you were to look at square footage and what decorating costs are for a house of this size and magnitude, it would have put the price of those improvement of the personal property over $900,000 to necessarily replace that. But those are critical factors when looking at there is no benefit. They're claiming that by converting an asset into cash from another type of asset, that's a benefit. And that's simply not the case. There's nothing to say that there was any gain or that anything was realized from it. And that's a basis to support to say, look, there is no benefit that was received as that term benefit is contemplated. And especially when looking at the whole agreement, and it talks about it's the sale, the transfer is of the marital home and the adjacent lot. There is nothing. What she's talking about is a different paragraph to say, hey, you can sell personal property and get a benefit, but that's, again, selling it for undervalue. And that's what we're looking at when we're talking about the situation with the personal property. So, and Judge Stargell, I think, hit on this, but we're talking furniture, tools, equipment, dishes, glassware, silverware, art, electronics, gym equipment, and furniture in multiple bedrooms, including basement, kitchen, family room, foyer, dining room, living room. This is a huge house. So for the former wife to say, I get that now, or I get half of that when she had absolutely no interest in it, and it's only for equitable distribution of a marital asset, is opposite of what the agreement says. And it supports the trial court's findings to say that side letter agreement for the sale of personal property is not subject to the wife's claim in this case. I'd like to move on to the second argument now, unless anybody has any questions on that portion of my argument on the side letter benefit claim. The second argument, Your Honor, is on the capital improvements. And Judge Casanova, I think you started with this on the first argument. This was a 2.5-day trial. And in that first argument, you pointed out that the appellate court doesn't sit to reweigh the testimony, the credibility of the witnesses, and then try and see, hey, would I have decided this case differently if I had heard this? Judge Jaraka sat for 2.5 days listening to testimony about these issues. He listened to the testimony about what were the improvements. What are we talking about here? A putting green. Mr. Braunstein, I believe, testified he was out at the house. He saw a putting green. It's on a spreadsheet. That's a capital improvement. So the first factor that I would point out to the court is that the former wife's case is really having this court try and reweigh the evidence and the credibility of the witnesses. It is not to look at it and determine it for anything else other than that, to say, we had our chance and we lost, and now we're going to come back in here. And the testimony of Mr. Jacobson, the son, they point to and say, well, we've got this issue now. We believe it's hearsay. Your Honors, we have cited it, but the hearsay cases that they cite, and it's important. The first case, they have the AS versus State case, and that was at 91 Southern 3rd 270. It's a 2012 4th DCA case. Interesting about that, Your Honors, is that it was a theft case or damage to a property. The garage owner was trying to testify off of the estimate that an employee had prepared. And the court said, look, the estimate didn't come in as a business record. But what is critical is they said, we're going to exclude that because he didn't testify that he had personal knowledge. They specifically said in the footnote, we note that the owner's testimony would not qualify as an expert opinion because he only testified as what was contained in the estimate, rather than evaluating what should have been included with the estimate and view the photographs. Had the owner looked at the photographs and said, I have knowledge of this, I know what to do, this is the damage, this is the estimate, the court would have had it. But they weren't doing that in that case. The other cases that they cite, the Thompson versus State case, interesting about that, there's a bill of lading that comes from Woolworths. When the bill of lading, it has how many product is out there. The people that were receiving the shipment testified they didn't get all the product on the bill of lading. The state didn't call any witness from Woolworth to say that's a business record, that the individual that wrote down the quantities was a person with knowledge at the time. We maintain a bill of lading as part of our regularly business practices. We put this down as part of the business that we conduct. And our records custodian would say, hey, yes, that's a copy of our bill of lading. So the appellate court looked at that and said, look, that is at odds with what the rule is for evidence. The other cases that they cited, again, when we're talking about personal knowledge on a note, the people that testified from the bank didn't know what was owed on the notes, and the court said you can't do that. Now, what we cited in the case, though, we cited one of this court's decisions in Mid-Florida Freezer Warehouses, and that was a 2010 decision, and this court found at 41 Southern 3rd 1014. There was an unemployment decision in that case, Your Honors. The employer, the former employer, testified, I saw this gentleman come in late. I personally counseled him that he was coming in late. I wrote him up. But the referee in that case said, look, all you've got are all these documents of him being tardy. And I'm excluding those as inadmissible hearsay because there's no business records that are introduced and there's no proper predicate. And in that case, this court noted that much of what the former employee testified was within his personal knowledge and was not hearsay. Therefore, there was a reversal to say that all that was inadmissible. Hearsay, Your Honors, is not when somebody's testifying from personal knowledge. We spelled it out in our brief, but the court specifically asked Mr. Jacobson, how do you know this? Mr. Jacobson said, I have personal knowledge. These are my father's accounts. I'm at Morgan Stanley. I know what improvements are in there. That is completely different from hearsay, where the witnesses that the cases they cited had no personal knowledge. That takes it out of the realm of hearsay. If the court were to adopt their standard, I couldn't walk in and say, that's my bank account, or I paid for that car, because I don't have the business record from Bank of America saying, this is a custodian, this is Mr. Samarkas's account, and this is what it says. That's not the purpose of the hearsay rule. The hearsay rule is to stop somebody that doesn't have personal knowledge from being able to testify unless there's an indicia of reliability. And that's why in a business record, that's met with the records custodian being able to set the testimony. So once Mr. Jacobson gave the personal knowledge, and by the way, Judge, this, Your Honors, he was out there frequently. This isn't somebody that went by casually. And we're talking about he's maintaining the accounts, overseeing everything that's happening with the accounts. He certainly has the personal knowledge. As to the schedules and the documentation, again, this is going to the weight of the evidence. We're talking about capital improvements. I go back to the putting green, partly because I'm a golfer and I think that's probably great, but anybody can see a putting green in the front of a yard. There's no dispute it's a capital improvement. The wife didn't walk in through her testimony and say, there's no putting green out there. How are they getting something for a putting green? There's no fountain out there. There's no improvements in the basement and the ground floor. There was opportunities even during there's nothing in the record that says they had no opportunity during the litigation to go out and dispute it. The only expert they put on is to say, we don't like their documents. Their documents are insufficient. But the expert that was the Appleese expert said, look, I look at the totality of circumstances. I look at what the testimony is from what Mr. Jacobson said. I'm looking at spreadsheets that have that, and I'm looking at the fact that these capital expenditures exist out there, that the improvements are actually there. That's the weight that the court gave that testimony. And then be able to say, no, we're going to go to some part of the agreement and say, gotcha. You don't have a receipt from 23 years ago saying that this was what you paid for the green. Therefore, I get the benefit of that. That's just not in keeping with an accordance of what the agreement says and what it was the parties to do. And when we look at the adequate backup documentation, there is the issue about the trust, that somehow his trust isn't him and he can't pay that amount of money. It's nonsensical. We mentioned this in the brief, that who is putting in $800,000 worth of improvement on a house and not paying for it? Who is writing checks to the guy putting in the basement, to the individual? If the company that's putting up I keep going back to the putting green, but the putting green, who's putting all those improvements in and paying for it if it's not Mr. Jacobson? There's no testimony that he had some grand benefactor out here that was paying for all of this. In fact, to the contrary, his son testified, no, he paid for everything. So the argument that they're saying that somehow, because there's no proof of anybody paying for this, is contrary to the evidence. And it certainly is contrary to the evidence that the court considered when the court was looking at the testimony and how to evaluate it. The other thing that the expert testified to that's important is that the expert, when I say the expert, Ms. Mills, our expert, she looked at what is the requirements for a capital expenditure. These are not maintenance issues. It is important to note, though, that Judge Duraka did ding my client for not maintaining it. He knocked off the price. He said, you're supposed to maintain it. You didn't maintain it. I'm taking 50 grand out of your column for that because you didn't do what you needed to do. There was testimony about whether these were capital improvements, whether he was maintaining the house, and what it is. And the expert who's looking at the IRS code and who is somebody that's a CPA and who's testified for many times, she testified that these expenditures were capital expenditures. And by the way, the judge also didn't accept 100% of what she said because the judge did knock down some of the capital expenditures and the capital improvements that were done. But clearly, Your Honors, the court looked at the fact that this agreement was not to benefit the wife by having the husband make capital expenditures over 23 years. And because he didn't have a receipt 23 years ago, even though there was testimony that it was done and it was paid for, that was somehow insufficient to demonstrate there was a capital expenditure, and now the wife gets the benefit from it. Especially, Your Honors, when you look at equitable distribution and say there is only the intent to give the value at the time that the asset existed, not to give the appreciation on an improvement that was not an asset in existence at the time of the marriage. Your Honors, the last thing on the attorney's fees, and we put this forth in our brief that we believe it's been waived, but this is an attorney fee to close a $5.5 million transaction for something that was $15,000. Clearly, that's benefiting the sale to go through a complicated transaction with the sale, waterfront property, lots, making sure the agreements have the appropriate contingencies in them, the appropriate conditions in them, the appropriate representations. And to now all of a sudden say, well, the husband has to basically eat all that and the former wife doesn't have to pay any of that when it's on the closing statement. And they have an opportunity to come in and say, well, we don't think that's legitimate because you weren't doing work on the closing on that. They say, well, we don't know what it was, but there's no evidence that they tried to know what it was, or they brought in an expert to say that's an unreasonable amount of money. And by the way, Your Honors, they didn't bring in any expert to say that these capital expenditures that were made were unreasonable and the values weren't there. They didn't bring in any expert or an appraiser to say the personal property was worth more than what it was sold for, and somehow this is a benefit. What they did was to sit back and say, we don't think you've given us enough information, and just at every turn, just say, we don't think it's enough. We now get the benefit from it, or the former wife would say that. In conclusion, Your Honors, unless there's no further questions, I thank the court for the time. We ask that the court affirm the decision of the lower court. Now you're on mute, Judge.
I noticed that just before I spoke, so your mind was working just like mine. Okay, thank you. Counsel, I intended to make sure you preserved your 5 minutes. I have, despite going over the last time. You mentioned that you might need the extra time. You have received it, so you have 5 minutes for your rebuttal. You may proceed.
Thank you, Your Honors. Appellee wants you to focus on items other than the applicable terms of the agreement. They cited numerous red herrings. First, as far as the side letter agreement, what happened is there was $500,000 given for property that was sold not in accordance with the fair market value. We requested to inspect that property to evaluate the worth of it. Appellee objected to our inspection of the property. They now rely on my client, wife's testimony as to the value of that property, which is irrelevant. She testified as to what it would cost a decorator to put brand new furniture in a brand new home per square foot. That doesn't determine what the actual value of this property was. The problem here is the property could have been worth $50,000 or it could have been worth $400,000. We don't know. We have to speculate. And without having that information, we're unable to determine how much wife is owed. If it wasn't the $500,000 and we don't know what it was actually worth, then that is unfair to wife and is not a fair reading of the agreement, which specifies that in this exact circumstance, where property is sold, personal property is sold in conjunction with the sale of the marital home and not for the fair market value, and the agreement doesn't say for less than the fair market value, the agreement just says not for fair market value, then that amount has to be included. We're bound by those terms, which both parties agreed to when they signed this agreement. We're not asking you to weigh testimony here. We're asking you to apply the unambiguous terms of the agreements. Regarding Mark's testimony in the business records, testimony regarding business records without the underlying business records is inadmissible hearsay. One piece of paper which wife requested and appellee refused to provide would have shown who owned that account in question. We don't know because they refused to submit those records and chose instead to rely on testimony of someone who is admittedly a witness who would gain for wife's loss in this case. I wanted to address the importance of the documents. Opposing counsel mentioned the putty green, and if you see it, then it's there and it was an improvement. But the problem is, Your Honors, how much did it cost? Without the documents, we don't have pertinent information that needs to be addressed in order to determine wife's equitable share. Without the documents, wife's expert was unable to determine if these were capital improvements. Appellee and husband had the advantage because they had all of these records and did not provide them as they were required to under the agreement to wife. This prevented wife from being able to conduct the analysis that was necessary. Opposing counsel mentioned assets that were not in existence at the time of the marriage. And I think it's interesting that he pointed that out because the huge $800,000 worth of improvements that were reportedly done in 2015 and 2016 were supposedly to install windows at the property, storm windows. But the testimony showed that storm windows were actually in place at the time the property was built in 1995. And that if you look at all of the records, it shows numerous window replacements over the years. And as he said, you can't get credit for what as a capital improvement for what was already there. It has to be an actual improvement. And without all of those documents, wife was prevented and her expert was prevented from making an analysis as to whether these were capital improvements. A great example of why the records were necessary are the Coley invoices, which are pages 5261 and 5262 of the record. Those were the only two invoices submitted that actually showed what work was being performed at the property, why it was being performed at the property, and the cost of that. And those were the only two that the judge struck. He struck them because when you actually saw what was being performed and why it was being performed, it was obvious that these were not capital improvements pursuant to the agreement. And this exemplifies why the records were so important. To summarize, again, the side letter agreement, it's simple. The agreement stated that if you sold personal property as part of the real property transaction for anything other than fair market value, you have to include the price of that personal property into the gross proceeds. For the capital improvements, 0 records cannot be considered adequate records. And for the attorney's fees, there was not evidence that it was a reasonable and independent selling expense. Yes, it was on the closing statement, but after the closing, appellee did not ask wife to contribute because they knew at the time of closing that those were not independent and reasonable expenses for the wife. So they chose not to bill it to the wife at that time. They only threw it in as an argument in closing arguments. So unless you have any other questions, I will rest now on our briefs, and I thank you. You're on mute, Your Honor.
You are absolutely correct. I was on mute. So we will say thank you very much to both counsel. I appreciate your presentations this morning. I think I speak on behalf of the entire panel. And that will conclude, I think, what they call our morning session. It's approximately 12:05. We'll take a 10-minute recess and come back for the afternoon session. So I guess I will say we are in recess at this time.